And while doing this, since the 80s moving forward, we're doing this, seeing the pitfalls and barriers within the system that individuals would face when reentering the community and getting back to their family. With doing this, it just started to grow and cover different areas from substance abuse to mental health to housing supports, as well as vocational supports. And recently, up to 4 years ago, the Center for Community Alternatives started an advocacy and organizing program for CCA members who wanted to really advocate and pursue civic engagement opportunities to reform these efforts and to push social justice and criminal justice movements forward. So with these past 4 years within advocacy and organizing, we were instrumental with helping bail reform get passed and signed into law in New York State, helping with Chief Judge Warren Wilson be nominated and elected as Chief Judge of New York State, helping with halt solitary confinement, as well as being instrumental with the Clean Slate New York Act being passed. And we're currently campaigning to undo the harms caused by the Rockefeller drug laws in the 94 Federal Crime Bill with Mandatory Minimums Act as a thing to think of with our Communities Not Cages campaign. So we're doing the work. Our whole goal is to end mass incarceration and mass criminalization of poor people in New York. And we're doing that through direct services as well as advocacy and organizing. So that's CCA, that's us. We're doing a lot. We try to really walk the talk, walk it how we talk it. And we are a statewide member base. So anybody that is directly impacted, and we look at directly impacted as being a person that went through any form of incarceration, whether at the institutional level, correctional facility, or any form of forced treatment, or that person's family member or loved one who went through that process with them, although they were not physically incarcerated themselves. We look at that as them having a direct impact, being directly impacted and experiencing a level of trauma while going through that incarceration with their loved one. So that's us, SCCA in a nutshell. I know that's a lot, but there's ways for folks to get involved with us, and we really look at it as long as you want to be civically engaged, we want to give you opportunities to be able to do that. So, Jason, I'll pass it over to you to introduce yourself and more about what Law in New York does, and then we can pass it back into going further into Clean Slate.
Thanks, Garrett. Kenny, if you want to go to the next slide. I won't belabor this much. I'm Jason Hogue. I'm the supervising attorney with Legal Assistance of Western New York's Reentry program. Law in New York has a number of legal services. We are not legal aid. We're in the same building as legal aid, but we do a number of things. We represent people and hear landlord tenant. So individuals facing eviction. We represent people on public benefits issues. We represent people on home foreclosures, insurance issues. We have a whole bunch of services. I always invite, and I used to be a former public defender, and oftentimes clients will raise issues that are a legal issue, but it's not one you as a criminal defense attorney, are going to be able to address, but it's still an issue. And so certainly always feel free to, pick up the phone to call myself or someone here at Law New York, because you'll find there's a number of lawyers here doing civil work that really is compatible and goes in hand with the work that you guys are doing over there. I'll turn it back to Garrett.
Thank you. And Jason is extremely instrumental with helping us with Clean Slate in Western New York. We just getting information out to folks, at the minimum. That's one of the things that we've seen with Clean Slate is that a lot of people, especially people who are within the eligibility for Clean Slate, people who have done the work and been in the community for a long time. We have seen, excuse me, you can go to the next slide. Apologies for that. We have seen that the problem is that there's people that's in the community that have, done the work, atoned for the crime and the charge that they were convicted for, and really tried to put their best foot forward with moving their lives forward from the situation that they were once in. And from doing this work as an organizer on the Communities Not Caged, the Clean Slate New York campaign, One of the things that I experienced from traveling across the state, excuse me, one of the things I experienced from traveling across the state is that the number of people who have been in the community for over 10 plus years have done countless things to make it despite of and still face the barriers and hurdles and the stigma or scarlet letter, so to speak, of their past conviction, no matter how long ago it was. A lot of individuals I talked to has been, released and back in the community since the mid 90s, and they're still experiencing these issues. And these issues that they're facing are ranging from housing to employment, as well as to secondary education, and they're all in the civil settings. So it's not anything that is. So it's the barriers that a lot of people are facing. The problem or the issue that a lot of people have is that the is preventing them from just the basic qualities of life, access to just the basic things that's needed, the basic necessities that's needed for themselves and their family to just sustain and maintain and to be able to live in New York. And most folks who have made it because another individual or someone really just extended the olive branch to them and took a chance on them. But if it wasn't for that, if it was just left to them to navigate through the system, it'd be very, very, very difficult. And it's difficult for millions of New Yorkers. As you can see, the estimated 2.3 million New Yorkers based on our four-part criteria of eligibility. If you go to the next slide for me, I greatly appreciate it. So here's just the history of Clean Slate. So it took us several years of campaigning to get Clean Slate passed. But in these several years, we really took a real grassroots approach and really tried to make Clean Slate as strong as possible with it being as inclusive of a law and as strong a common sense of a law as it can be, where it factors in all 62 counties and the demographics within all 62 counties. Really try to factor in folks that's living in the North Country and dealing with issues related to poverty and disparities related to poverty, especially when that factors into the criminal justice system, as well as looking at the Southern Tier in the Finger Lakes, as well as the Hudson Valley region, actually talking to folks in Delhi, New York, and asking what their thoughts are on record sealing and how that's impacting their community. And we were able to, almost like a quilt-like situation when you think of like grandmothers, but in a quilt-like way, in fashion, weave together a very diverse coalition that brought in different perspectives under the same common denominator of making second chances a reality, but brought us different perspectives of how to really make a really strong, inclusive, no-nonsense type of law that can be improved over time and refined and even better for New Yorkers, work better for New Yorkers as a tool. So you can see here, it's a list of different groups that is broken into categories based on our coalition base, but it really ranges from J.P. Morgan to 100 Black Men. Like, it's really so many different organizations, groups, unions, district attorneys, former superintendents that's been part of the coalition, with just moving it forward and seeing how important of a message it is and how much of a reality it can be for New Yorkers. So with us doing this, Clean Slate was passed by both houses in June of 2023, and it's signed into law by the governor in November of 2023. That's why you see there it has a one-year enactment date of 2024. And then just moving forward, just to give you guys a heads up, you could go to the next slide as well. But just to move forward, Clean Slate has a full-on implementation period, which is a 3-year period. Clean Slate is looking to actually become a reality where moving forward is just a thing for New Yorkers, right? So planting the trees for the forest will be 2027. That's the time frame that the state agencies have with implementing Clean Slate into New York State. And in that process, we're doing things such as this. We're meeting with you guys today, but then also just trying to go across the state, across the 62 counties, and provide the information and resources individuals will need to clear their records, to clean up what can be cleaned on their records based on the current laws, while waiting for eligibility for Clean Slate. So just to wrap up my end, Jason, I know you have quite a bit of it that you want to cover with folks. So Clean Slate is automatic. and it's automatic based on some of the laws that Jason is going to be highlighting for you guys later on in the presentation. But it's automatic sealing for convictions for most civil purposes. So here's some key points. No application required. That's a huge, very crucial point to make. There's no application required for a clean slate. Sealed records will not show up on background checks when applying for most jobs. So there are some jobs, employment positions that are the agency or entity would still have access to a person's record. So it's important to note to people that it's a civil sealing law. And then sealing does not expunge or destroy a person's records. So those are some key points to note with Clean Slate. And if you can move forward to the next slide, I can address some further things. So our eligible offenses in waiting period. So DWI infractions is a 3-year waiting period, as well as with misdemeanors. So 3-year waiting period from the date of sentence. So date a person was sentenced is their waiting period starts from there. And then for felony convictions, it's an 8-year waiting period. It is from the date of release. So the date a person is in the community, their time starts. So that's where you think of the difference. So with misdemeanors and DWI infractions, think of date of sentence, and for felony convictions, it's date of release. And that's it's some reasoning into that, and it's some logic into that. The main logical point to take from that is the way that county jails are operated, as well as the way that they're tracked with information. If a person does a county year, for example, the way that information is shared with the state agencies and with the Office of Court Administration, it's a more streamlined process when you factor that in to go based off a person's date of sentencing, just tracking wise. Is more efficient. The other offenses that are not eligible, is easier to explain the ones that are not eligible because it's a shorter list. So sex offenses, and then sexually violent offenses, and Class A felonies that are not, unless they are drug possession or sale felonies. So any violent Class A felony or any sex offense are conviction related to a sex offense. So any sex offense related conviction or sexually violent offense or Class A violent felony is not eligible. Is not an eligible offense for clean slate sealing. And then how the waiting period is calculated. I did this earlier, but just to reinforce it, the time starts running on the day a person is sentenced or released from incarceration, whichever one is later. You can go to the next slide for me. And then when the time period runs, the case will be automatically sealed unless. So here's some stipulations. So if a person has a pending criminal charge, or if they are still on parole or probation. So you have to complete your community supervision. And then you can have no pending charges, nothing that still needs to be resolved in court. And then your case will automatically be sealed once the person, again, has no longer pending charges and complete parole or probation. So if you look at the 4-part criteria, once again, it's the conviction must be eligible where it's not a violent A1 felony conviction or a sex offense related conviction. You must complete all your time incarcerated unless you're sentenced straight to the community. And then the third is you have no pending charges or pending cases upon your sealing date, your automatic sealing date. And then the fourth is you're off all forms of community supervision. So it's a 4-part criteria, and then within your actual conviction, whether it's a DWI, misdemeanor, or felony conviction, you will have either a 3-year or 8-year waiting period. Go to the next slide for me, I appreciate it. And I believe that is Jason. So just the last thing I just want to say before passing it over to you, Jason, is the one thing to mention or to note with the waiting periods is that if a person is on a felony waiting period, so they had a felony conviction, they served their time, they're on their waiting period, they're no longer on parole. They're just waiting. They may have 2 years left in their waiting period. If they receive a misdemeanor conviction, as an example, where it's a 3-year waiting period, even though it's a 3-year waiting period and it's a misdemeanor conviction, that restarts their felony waiting period. So they have to start the full 8 years over again once that misdemeanor conviction, the case is resolved, et cetera. Once that's completed, their 8-year waiting period restarts. So that's something to note. That's where it's mentioned with Clean Slate being a no-nonsense bill, and really self-accountability and self-reliance is woven into that, because it's really the onset is on that individual to be able to fly straight in a way. Jason, it's all yours, brother.
Thank you, Garrett, and thank you for all the work that you've done and CCA has done. This is really an amazing, this is going to be progress for the state. Just want to say real quickly, Michigan did Clean Slate maybe 5-6 years ago, and they did a study. Harvard Law actually did the study, published it, and they found within 2 years of this law, people that had their records sealed were making 25% more. I mean, there's a direct link, and we see that all the time with people with criminal records. They're losing employment, not being able to get into higher education, not getting able to professional license, all this because of these convictions 10, 20, 30 years ago. So this is really going to be a real start of real sea change here. But so real quickly, okay, November 16th, we're talking literally what, like 5-6 months away, something like that. My math, that's why I went to law school. Math is not my strong point. But November 16th is coming fast. On November 16th, there's going to be a couple different folks. There's going to be folks who, their conviction is, over 3 or 8 years ago, but they're currently on probation, serving a probation sentence, or they're currently, say, incarcerated, or they're currently, maybe they have a parole violation, or they have new charges. Those folks are going to be paused because it won't go into effect because they're basically been pressed pause. So these events are both a pause and kind of a restart. So like Garrett was saying, there's going to be folks who, let's say, they have a misdemeanor from 10 years ago, okay? And it's an eligible misdemeanor. It's a petty larceny, okay? They don't have any new criminal charges. They're not on probation. They're not on parole. They're going to say, yeah, it's super excited. My record's going to be sealed. Well, maybe not, because as Garrett said, there's an implementation period, which is of 3 years. So people are going to hear this news, go to look at the records on November 16th, and maybe they're going to be really unhappy to find that the record's not sealed. However, what we do know is that the OCA is going to, this is in the statute, this is CPL 16057, the OCA is going to make a form by which individuals who on November 17th, who have a felony from 20 years ago, and it's a burglary second, or they have a misdemeanor petty larceny from 15 years ago, and they're not on parole, they're not on probation, they don't have any current charges, and they would be eligible for this relief. What they should be able to do is send this form into the court, to the OCA, and that record should be sealed under this. And we're hoping to help that happen. But to the slide, the folks that either are going to get a pause or a restart. So if an individual, let's say they have a misdemeanor from 5 years ago, November 16th turns the date, and they're looking to have the record sealed. However, they have a pending, let's say, petty larceny. Well, it's not going to go into effect because they have this pending charge. However, if the case is dismissed, boom, the pause is off. If the case results in a harassment or a discon, it's a violation, as we know is sealed pursuant to CPL 16055. The pause is going to stop. However, if they are convicted of another misdemeanor, then it's going to restart the waiting period. If it was a felony, 8 years. If it's a misdemeanor, 3 years. There's going to be folks who on November 16th, 2024, go to look, they'll see their records are sealed and they're on probation or they're on parole. That's going to be a pause, okay? However, once they are off parole or probation, that pause lifts. However, let's say they get a violation in terms of a violation is filed. So let's say they have a conviction from, let's say, 10 years ago. However, they're currently serving probation for some reason. Well, when the law goes into effect, they should be eligible. But let's say on November 16th, a violation is filed against them. That would put a pause unless it's not sustained. Then if they're restored to parole or probation with no violation, then they would be eligible. If it is sustained, but they don't get reincarcerated, let's say they just get restored, then the pause would lift. Okay. However, if there is a violation that is sustained during that waiting period, okay, either probation or parole, it's going to restart the clock. Can you do the next slide, please?
Yes, I am going to share the first digit of the code, though. Okay, so the first digit to the code is the number 2.
Number 2, everybody. So the first number of the code was 2. How is it going to seal? As we know, as most people, there is no such thing as an expungement in New York State. Even though there are that language, expungements don't actually exist in terms of when you seal. It's really what we do is New York is sealing records. Okay. So really, when you're talking about sealing records, it's because records not been destroyed, it's who can view that record. So under CPL 16057, okay, which is going to go into effect, who it will seal to? Basically 99% of all employers, okay? So any employer that's doing a background check, as long as they're not actually doing fingerprint background checks, and those, I can list off to you who those folks were going to be. But Wegmans, Walmart, places like that, they cannot do fingerprints and don't do fingerprints. The records will be sealed to them. Landlords, building management, so for housing, records will be sealed. Educational institutions, they're not doing fingerprints, they'll be sealed to them. Who would the records not be sealed to? Well, in terms of these records are who they're not sealed to already, actually, which is police and prosecutors, defense attorneys, the judges. So they'll still appear probably on a unsuppressed criminal history. And then agencies doing background checks either for law enforcement jobs or for handgun licensing. And that's true already. So if somebody gets a youthful offender or someone gets an acquittal, that information would be on an unsuppressed record, which a law enforcement agent would review for a job with law enforcement or with handgun licensing. Also, the Department of Motor Vehicles, DMV. So these would still appear, understanding is on DMV records. So next slide, please. What employers can still see the records? So employers that will still be able to seal these sealed CPL 16057, most likely it's not actually going to be the employer themselves. What it's going to be, and this is what I do a lot of work with, is state agencies that are doing background check clearances. So if you want a job with, say, to be a home health care aide or a certified nurse's aide, you have to have your background check submitted to the Department of Health, and the Department of Health reviews that information and makes a decision. So the Department of Health will still see that information. So this is important for people to know because, a lot of people are going to hear, hey, my record's sealed. I don't have a record anymore. Well, kind of, sort of. If it's under CPL 16057, it's sealed on a clean slate, then it will still be viewable for, say, the Department of Health, or if someone was working, say, security guard, that has to be done through a state licensing agency, or in terms of jobs that are like, say, with office, the ARC, which is like working with the Office of People with Developmental Disabilities, or working with the Office of Family Child Services. Again, it's going to be fingerprints. That's how you're going to know. It's going to be fingerprints. The New York State Education Department, which handles in terms of, say, LPN licenses, RN license, social workers. So these professional licensings, because they have moral character and fitness reviews, they still will be able to review this information. And then I don't know how they slipped this in, but Uber and Lyft. Now, I find this very hard to believe that Uber and Lyft are actually going to get access to these records. And the reason for that is that all these agencies I've named are really named in a statute. This is executive law. 845, which actually lists the agencies that can do fingerprinting. And I can tell you, Uber and Lyft are not on there. So I don't know how they would actually get access. So I don't really think this is really going to be viable for them, because you need to be able to do fingerprints to actually see these sealed records. So next slide. So these are examples of what's going to happen. So let's say somebody gets convicted of a misdemeanor in 2024. They get sentenced to 3 years of probation, okay? And then they get discharged after 2 years. When's their record going to seal? 3 years later. It's going to be 3 years for a misdemeanor, and they were convicted in 2024, so their conviction will begin sealing on 2027. All right, individual gets convicted, and this is number 2. Person is convicted of a felony in 2020. They serve 5 years in prison. They are released to parole in 2025. They have no violations, no convictions, no pending charges. When will their record seal? It would be 8 years from the release of their incarceration, which was 2025, which I guess my math will tell me, luckily I did math here, is 2033. Next slide, please. All right, so here, number 3, we have an individual who's got a felony, right? They're convicted in 2020. They're released in 2025. However, in 2026, they catch a VOP. Let's say they get sent even into, gets reincarcerated, and then they're released in 2026. When will their record seal? Again, just math here. It's going to be 8 years later, and that is from 2026. My math tells me 4 and 4 is 2034. And then finally, an individual who is convicted of a felony in 2020, they complete a mandated drug program. In 2026, they get convicted of a misdemeanor. Okay, and then they're sentenced to jail for a year. They get out in 2027. Okay, when's the record going to seal? It would be 3 years for that misdemeanor. So it'd be 2030 that the misdemeanor will seal, and then it would be 8 years, and that's 2035 for the felony. And I'm going to answer your questions after this if you have questions, but can we go to the next slide? It's important to remember that Clean Slate, really, I do reentry work here, and New York now has a bunch of tools that we can help people with criminal convictions. So Clean Slate is certainly fantastic, but it's actually just one gem in the ring. We have a number of other statutes. We have CPL 16059, and these all stay in effect. So CPL 16059, which is a statute I use quite a bit, you can completely seal somebody's record such that it's only accessible to law enforcement or for handgun licensing. And somebody could have been arrested one time, got acquitted, right? And so they didn't do it, and the case is just dismissed and sealed. Their record would still be turned over for handgun licensing and for a position with law enforcement. So that, unfortunately, always an exception. But CPL 16059 allows us to seal records even further than Clean Slate. However, those folks have to have no more than 2 convictions, no more than 1 felony, okay? And it has to be not a violent felony offense, and it can't be a sex offense. And it has to be 10 years since the date of the conviction, or same here, release from incarceration. So CPL 16059 is a statute I use all the time. And so if you see folks that have just 1 felony and they come in on a discount for you guys and you get that discount for them, you should tell them, hey, buddy, you could probably seal that felony, or Clean Slate is going to seal it for you. 16058. This allows for the sealing of specific drug convictions. It's really got to be a 220, a controlled substance, or a Willard. I don't think Willard even exists anymore, but what's called a Willard eligible offense. So if they have a 220 or one of these Willard eligible offenses, and then they did a judicially sanctioned drug treatment program and didn't get convicted again after that, they can seal very specific convictions. I've done one of those over the course of 10 years. They're hard to identify as the main issue. I'm sure there's lots of folks out there, they're just hard to identify. CPL 446A. This is MRTA. This is the Marijuana Reform Taxation Act, which is, as most people know, 221s don't exist anymore. Most 221s were automatically, the state has actually already done these automatic sealings. They automatically sealed for most part, almost all 221s. However, you do see some left around. If you see them on a record, more than likely that person fell in this weird gap, and they can either reduce that felony to a misdemeanor, or maybe that misdemeanor a violation makes them have no criminal record. Or they might be actually entitled for some type of expungement. So there are some of these 221s that kind of fell through a gap, and they're not automatic. And so that still exists. And then CPL 72020 subsection 5. This permits individuals who were denied a youthful offender adjudication and then went on to have no criminal record. I've seen a few of these, but because of both these 440s and these 720s, because we're a legal services corporation, we can't do any criminal work. I'm unfortunately prohibited from doing these. But the public defenders and other attorneys can do these when they see them. So somebody who has a conviction at 16, maybe for a Berg second, and then has no convictions after that, they could be entitled to actually have that felony sealed as a retro youthful offender. If you want to go to the next slide here.
Yep, I'm gonna
Yes.
say the next digit of the code. It's the number 8.
So number 8 is the next second digit. All right, so I'm gonna try to fly through this, guys, so I can give time for questions, because I'm sure there's some questions. What I want you guys to know is that this is a little known fact, that criminal records in New York State are actually a protected class. We're one of the few states that does that. What does that mean? That means that under human rights law, a person with a criminal conviction or with a sealed arrest record are actually protected under human rights law. So in New York State, it's unlawful discrimination to be told, oh, hey, we did your background check and we saw you had a felony from 30 years ago. Well, sorry, you can't work here. We don't hire anybody with a felony. Now, it'd be problematic saying that anyways, just under Title VII issues. But individuals in New York are protected under what's called Corrections Law, Article 23A. And so what that says is basically an employer can't just simply deny somebody employment or the state or professional licensing just based solely on the fact they have a criminal record. I'll talk a little bit more about that. Next slide. So in New York, if a conviction is sealed pursuant to 16050, 16055, or youthful offenders, those records are sealed, and it's unlawful for any employer, for any state agency, or any housing provider to say, hey, tell me about every time you got arrested. I want to know if you've ever been arrested before. That's actually illegal, and the individual who faces such a question like that, they can, as next slide. So when an employer asks, let's say, well, the employer asked that, says, have you ever been arrested, Jason? I can, next slide. I can say, nope. I'm actually authorized under the statute to deny that I've ever been arrested if that conviction has been sealed pursuant to 16050, 16055, 720, or any of these other sealing statutes. So next slide. Yeah, so that basically, as I just said, this is actually the language straight from the statute, which is that if a housing provider or an employer says, hey, have you ever been arrested? And I, let's say, was arrested and I got a youthful offender, I'm permitted to say, nope, never. Next slide. This is information that I find is really important, and I'm not sure everybody's aware of it. Let's say you have a client that comes in, right? And let's say you're in arraignments. And the DA says, hey, I'll offer you an ACD today, 6-month ACD. And your client's saying, oh my God, I lost my job. I need to get my job back. I can't wait 6 months. Here's the thing. They don't have to wait 6 months. This is like kind of slipped through. This is actually since 2019. Little known fact is that on the date that an adjournment and contemplation of dismissal is granted, I know it's not going to get sealed. I know that. I know if you go ask the clerk to give you a disposition, it's not going to say it's sealed. It will say it's granted, okay? And the day it's granted, for employment purposes and for housing purposes, it becomes unlawful for any state agency or any housing provider to inquire into that case or to use that information. So the date that you have somebody who is granted an ACD, although it's not going to seal, okay, so if they run a background check, unfortunately, it may come up. However, what you need to advise that individual is say, hey, if you have some type of background check or you've lost your employment, what you need to do is go back and tell them, I was granted an adjournment and contemplation of dismissal. They might have to give a certificate of disposition or send them to me. I do this all the time. A lot of times I'll have calls from conflict defenders, from public defenders, private attorneys, and they're saying, my clients, here they're crying, they lost their job. I've been offered ACD, but they can't wait a year. They don't have to wait a year. Just go in, do that ACD, get a disposition, and then send it over to me, and I'll be able to save that person's job. Next slide. Pending charges. So in New York, there are protections, which we'll talk about in a second. Once the person is convicted, person's charged with a misdemeanor, they go and plead to that misdemeanor. Corrections law that I just talked about is going to kick in and protect them. They go to court, they're charged with a misdemeanor, they go to court, you get them an ACD, they're going to be protected under human rights law, that's 296 subsection 16. However, you got a client says, I want to go to trial. I want to go to trial. Well, while that case is pending, there is no presumption of innocence. Can you go to the next slide? Unfortunately, in New York City, they do have some protections. That's called the Fair Chance Act. Obviously, that's a municipal law. Doesn't apply here. But in New York, in upstate New York, if someone's charged with a crime, that information can be used against them in their employment and housing and professional licensing. Okay, there's no presumption of innocence in the civil realm. Okay, and so employer can use that information. But if they pled guilty, then corrections law kicks in. Or if you get that case dismissed, you get reduced to a violation, you get an ACD, that's going to kick in these protections. Next slide. And so those protections I'm talking about are, for example, one example is federal law, Title VII. The EEOC, which enforces Title VII, has put out guidelines that says that using criminal records, just using criminal records in employment and housing, absolutely have a disparate impact, an unlawful, discriminatory disparate impact upon people of color. And you can maintain a federal lawsuit under Title VII in that. Oftentimes when I have clients who have, say, drug addictions or past drug addictions, and they have histories of criminal records of that, I will try to use actually the ADA, the Americans with Disabilities Act, claiming that it's a symptom of a previous disability, because addiction, if it's treated, is a disability. And a criminal record, you can argue, is a byproduct of that. Human rights law, 296 subsection 15, that states unlawful discrimination against somebody based solely on a criminal record. And Human Rights Law 296 subsection 16 makes it unlawful for a housing provider, an employer, a state agency doing licensing, really a whole swath of the public from inquiring into sealed records. And then New York Corrections Law 753, that's Article 23A of the Corrections Law, that states that it's unlawful discrimination to deny someone employment based solely on a criminal record. Next slide. So basically, Human Rights Law 296 subsection 15, that's a implementation. It allows individuals who have been discriminated based on a criminal record to either file in the Division of Human Rights, and I do a lot of cases in the Division of Human Rights based on criminal records, where people get hired, they have a background check and told, oh, hey, we saw that you have this felony. You're perfectly qualified, but we just can't have you here with that felony. That's most likely unlawful. And we enforce a law, and we recover, just in the last 2 years, we've recovered close to $100,000. And this is for people who applied for, a cashier job at a gas station and didn't even get hired. We're recovering $7,000, $15,000 for these individuals. Next slide. So this is the law, New York State Corrections Law, Article 23A. Basically what it says is that unlawful discrimination to deny somebody a professional license or an employment in New York based solely on a criminal conviction. There's two exceptions, whether that conviction is direct relationship, okay, which is very specific, or whether that conviction poses unreasonable risk. A direct relationship example I always give is that I'm a lawyer, I embezzle my client's money, I get convicted of embezzlement, I lose my law license for that, and then I reapply for my law license, they're going to probably tell me, no, we're not going to license you because a direct relationship, your embezzlement conviction is from your direct employment or licensure as a lawyer. Unreasonable risk looks a little different. Can you go to the next slide? There's 8 factors that got to be considered, and this is true either whether the employer is doing a direct relationship or unreasonable risk. They must show they consider these factors. I sue employers all the time because they deny somebody based on a criminal record. When we bring them to the division or court, they immediately say, oh no, there's an unreasonable risk. But they can't point to that they ever did these factors. And the factors are really common sense. And this law is not a new law. This is from the 70s. And this law basically says if you're going to deny somebody employment or professional license based on a criminal record, you have to do these factors. 1, it's public policy to encourage employment among those formerly convicted of crimes. 2, what's the specific duties and responsibilities of that job, and how is it related to the conviction? 3, what's the bearing, if any, that criminal conviction would have on that person to carry out those duties and responsibilities? And what that's telling you is there's got to be a connection between that conviction and the job. 4, how much time has elapsed? Was it 10 years ago? Was it 5 years ago? Was it 2 days ago? Next slide. Then, well, I'm missing some factors there. I can tell you the rest of the factors are age at the time, obviously a difference between being a 22-year-old convicted of petty larceny and a 55-year-old. The evidence rehabilitation the person has, what they can, produce, anger management, community service, drug treatment, whatever it is. And then finally, the employer's, legitimate interest in protecting their property, the public, their staff. And then most importantly, the employer or state licensing agency must look to see whether there's a certificate of relief from disability or a certificate of good conduct. These are what are called certificates of rehabilitation. Next slide. So what is a certificate? A certificate doesn't seal somebody's conviction. It doesn't expunge it. But what it does is one of 2 things. It is 1, legal evidence of the rehabilitation, okay? And so that means when I'm applying for a job and it says, have you ever been convicted of a crime? And I have to put down, yes, I have a felony from 2 years ago. And they're going to ask me to explain it, right? And I'm going to say, well, I'm rehabilitated. I went to drug treatment. I successfully completed that. Here's some proof of my treatment. But it's me kind of making the case that I'm rehabilitated. What the certificate is the court that convicted that person or docs, saying this person is legally to be found rehabilitated. And that employer must, or that state agency, or that housing provider must overcome that. And then the second thing it does is really powerful. And this is really important, I think, for advocates to remember. Anything that person's conviction, whether it's be a misdemeanor or felony, anything that they cannot do because of that, and there's a number of barriers or employment. Let's say if you get convicted of a felony, you can't be licensed to have a firearm. If you're convicted of a felony, you can't be licensed to be a security guard. There's a number of licenses on different things that you can't do. If somebody's issued a certificate of relief from disability, and it's issued and it's most expansive, it reverses every single legal disqualification and barrier out there. Everything in New York that says you can't do something because of felony or a misdemeanor, it's automatically reversed by the issuance of a certificate. It's really powerful if you have somebody who's like worried about going to school or worried about, a professional license. And next slide.
Sure, I'm just going to share the third part of the code. That's going to be the letter J.
So the next code was J. J is in Jason. All right. So next slide. So here's some case law. These are the 2 Court of Appeals decisions on it. Really interesting reads. And next, in terms of next slide, do want to let you know there's 2 certificates, what's called a certificate of relief from disability. That's for individuals with no more than 1 felony and didn't serve any prison time. Okay. And they would apply to the courts that convicted them. So, and then you need 1 for each conviction. So if I have 15 misdemeanors and 1 felony, I need 16 certificates. Certificate of good conduct. A certificate of good conduct is for somebody with more than 1 felony, so 2 felonies, or they did prison time. Okay. And the good news about that is if I have 2 felonies and 15 misdemeanors, I need 1 certificate of good conduct. Covers everything. Also, what's important to remember is that anybody who's in New York State, and it doesn't matter if the conviction's from Pennsylvania, New Jersey, or it's a federal conviction, they can apply for a certificate of rehabilitation at the docks. And so the New York will issue certificates for convictions out of New York. Next slide. I told you before, what does the certificate do? Okay, it's not an expungement, doesn't seal the conviction. Person still has to report they have a conviction, okay? But it is a legal presumption of their rehabilitation. And most importantly, it restores all their rights. It immediately stores all the rights that were removed to them upon conviction. Next slide. This is the information about the two certificates. The two certificates really do exactly the same thing. There's only one difference. And if you look on the right side under certificate of good conduct, the only difference between a certificate of good conduct and a certificate of relief from disability is that it will restore your ability to hold public office. But it's not like Donald Trump. Donald Trump gets convicted of a felony here in New York tomorrow. He can still be the president. He can still run for state office. It's not elected office. What it is it's a notary public or a police officer or firefighter. Those are the positions I usually see. The certificate of good conduct is necessary, okay? So if I had just one felony, I never went to prison, I'm only eligible for a certificate of relief from disability, but I want to be a notary. I need a certificate of good conduct. And then I apply to docs and make very clear that's what I'm doing. Next slide. Certificates are super flexible, okay? One thing that's really important to remember, and I actually have done this as a public defender, they can be issued at sentencing. Now, judge is gonna be like, counselor, come up here. The certificate, I'm gonna say this person's rehabilitated, I'm convicting them today. Well, judge, here, I understand that, but here's the thing. My client is a home health care aide, okay, and she lost her job, and you're going to fine her, and she needs to pay that fine, and to do that, she needs a job. She has a job. This conviction has nothing to do with her employment. Let's say it was a DWI. She's going to take the bus, judge, and she doesn't drink at work. Judge, we need this certificate to stay for a job, which is true. And so judge can issue a certificate at sentencing stage. I find it's where it's most persuasive is you can identify a job or education or something the client is doing now. And you can ask the judge and you can limit it. You can actually say, judge, okay, don't restore their gun rights. Just limit this to use in the Department of Health for her job as a home health care aide. Or it could be temporary. Judge going to put her on probation. We're going to make her pay some fines. Make it temporary until she pays her fines or completes her probation. It could be conditional. Make it conditioned on her, paying her fines. So there's a bunch of different tactics you could actually use to try to get these certificates at sentencing stage. Next slide. And I always point this out too. A number of years ago, the legislature actually put reentry and rehabilitation into the penal code. And to remind judges that, when they're doing sentencing, it's important to think of reentry and rehabilitation. And so when I'm asking for one at sentencing stage, say, judge, a number of years ago, the legislature actually put this in because they wanted reentry really to start at the beginning, not to wait till, the person runs into these issues. I believe that's my last slide. All right, questions?
Okay. I'm going to share the last part of the code. It's going to be the number 5. And then we do have a question for Garrett. Okay. At sentencings, when we're trying to convince a judge to not put our client in jail or prison, do you have any studies or papers you would recommend for us to use in our arguments?
Sorry, repeat the question for me one more time.
Yeah, no problem. At sentencings, when we're trying to convince a judge to not put our client in jail or prison, do you have any studies or papers you would recommend for us to use in our arguments?
Oh, well, studies, we actually use the studies from the Brennan Center and Vera Institute to quantify this actually with excessive sentencing, but that's related more so with our Communities Not Cages campaign. I can send that to you to be able to cite, definitely.
Yes, I think Jason just sent it.
Do you know who sent me do you know who had the question? I can
yes.
follow up with them.
Yep, I can give you her email. I'll
Okay,
send it to you after the CLE. And I believe that was our only question. Does anybody have any other ones?
And I dropped in that. I just dropped in the Prison Policy Institute along with the stuff Garrett had cited. I find they have very, very good data and you can get it down to county level.
Cool. I actually wanted to address the Uber situation, right? Because it's an example of the larger picture with Clean Slate. With one of the things that we tried to do with making sure that Clean Slate did not cause disruptions, or I mean disruptions as in to the individual New Yorker, right? So like we didn't want to have something where it's well intentioned and it cause more harm than good in actual practice. So one of the things that we're being very conscious of is wherever there are current ceiling laws or lawsuit that these protective laws in place for the individual New Yorker, we tried to make sure that those were maintained. So wherever it's admissible, leaving it there. Wherever it's permissible, leaving it there. And one of the things in New York City, in particular with Uber, was that localities that have been allowed by the state law to write requirements for contractors, for example, Westchester with trash haulers, but then you have New York City with Uber drivers, where Uber drivers are required by state law to get fingerprinted, but an exception was written for New York City's regulations on fingerprinting that would apply for Uber drivers. So in New York City specifically, they have that set up for Uber drivers that predates Clean Slate. So because it was already in place and it was something that worked for the people within that locality, where it's like, hey, if it's not broke, don't fix it. If it's working for the voting, tax-paying public, let it maintain to work for people. And if it's, where it can be improved, it can be improved. And that's the logic and reasoning we went in with this. So when you see things like Uber being there listed or Lyft being listed, that was because of the protections in place for New York City and commuters in New York City.
Okay, we do have one more question. An attorney asks, when a client has gotten no new charges since 2008 and has a new petty larceny, am I correct in understanding that an ACD or discon would not reset Clean Slate time?
Yeah, that's exactly right. As long as that they don't get convicted of a new crime. And so even if they pled to a violation, that would not reset it. So yeah, an adjournment contemplation, definitely not a conviction. So definitely wouldn't reset it.
Great. I think that was our last question.
All right. Well, thanks everybody. I really appreciate, the opportunity to talk to everybody. And if you have questions, always reach out.
One more thing. Oh. Am I able to upload the PDF into the WebEx platform? Because I can share that PDF now if possible.
You could share it up at the top corner, or if you want to email it to me, I can send it to the attendees afterwards.
Okay, I can email it.
Sure, absolutely.
Yeah, I can email it. It's a 4-page, so okay. Perfect.
Alrighty. Well, thank you both very much. I greatly appreciate it.
Thank you. Thanks for everybody's time. Have a great day.
You too. Bye, guys.
Bye-bye.